Hello, Cyclop presents the Clancy Litigation Group in another of our seminars defending against false allegations of sexual abuse. Today we're going to talk about trial preparation and the use of technology. We want to talk to you today about how we prepare child molestation cases for trial. There's a method of combining technology in case preparation. The use of technology is inseparable from case preparation. We'll also tell you about how to prepare your expert using the same kind of technology that we're going to talk about with respect to the facts and witnesses in your case.
We're going to start, first of all, by discussing what we call pre-files. In private practice, unlike public defenders, you often have a time when the client comes and hires you before any criminal charges have been filed against him. We call this a pre-file. It's the best time to meet your client.
The first thing we advocate is to tell the client that he or she is his own worst enemy. Tell them to shut up. Remind them about pretext phone calls, which is a technique being used rather extensively in California, where the child, with a cop listening on the extension, calls up and says, "Why did you do this?" Remind the clients to shut up. They are their own worst enemy. The next thing we advocate is a preemptive investigation. We always begin our investigation as quickly as possible after being retained. Why? Because we want to prepare the battlefield. Criminal defense attorneys are constantly responding as the tail, with the state and prosecution being the dog. Try to turn it around the other way. Prepare the battlefield. Stop the flash fires. Get everybody together. Circle the wagons, as it were, and try to get people to pay attention to the overall case plan. It's important to start this early because one of the things we are trying to do is win the hearts and minds of the various witnesses. We want to appear professional. We want to appear truthful. We want to get our investigation going in the right direction immediately.
What do you look for in the investigation? Motive, motive, motive. Anytime that you want to win one of these cases, the jury is going to sit there and say, why would they be making a statement if it isn't true? And so if your investigation has to focus on one issue, it needs to be motive. A secondary part of the investigation, especially with younger children, is sexual knowledge. A young child cannot describe intimate sexual acts. However, normally you will find out that they have learned it from their older brother, the kids at school, or even through multiple questioning by investigators. You know, the first investigator asked him if the penis was hard, and the child looked in a puzzled way. The second investigator the next day asks if it was hard, and the kid answers the question. Why? Because he learned about sexual knowledge from the earlier interview. The other thing you need to do in an early investigation is to look for 1108 evidence, evidence of other wrongful acts by your client, and get to the witnesses as fast as you can.
It's important that you remember that your role is as the lawyer, not the therapist. The family members and the client, particularly during the preemptive investigation, are going to want to counsel with you. Remind them consistently that you are the lawyer, not the therapist.
What you want to do is to be a filter for your client. Gather all the information. Many times there may be some exculpatory information that could end the case before it even gets started. You don't want to subject your client to a police interrogation. However, you can be a filter and pass this favorable exculpatory evidence on to the police. Next, you should call the DA and let them know you're available in case they are going to charge your client. That you will surrender him so that you can make bail arrangements, and more importantly, so that any exculpatory evidence that you have can get in at an early stage and maybe nick the case in the bud. The next thing we want to talk about is the method by which we go about assembling data. The first thing you need to do is get that discovery. Remember, information is power. Get everything you can. Use our motion banks. We'll talk about that more later in order to get discovery. Obtain all the information that you can from your client and start assembling it. I recommend that you do formal discovery. There are too many times when I've been in the middle of a trial and the district attorney has popped up with something that they had not given me earlier. If you do not have a formal discovery order, it's going to be impossible to get sanctions. You should be using a subpoenas ducis tecum or the discovery statute, Penal Code Section 1054, to get all of your discovery. The DA will sometimes play a game. Sometimes they will say, well, we're not required to get that discovery. We don't have it in our possession. And yet, if you issue a subpoena, they say you're not allowed to issue subpoenas because that's not part of the formal discovery rule. I have a way of doing it. I issue the subpoena to bring the documents to the discovery motion. Then, whichever way they argue, you have the other way covered. That puts an end to the game. In juvenile matters, you face a conflict or a fight between obtaining of juvenile matters and constitutional due process. However, you are allowed to get juvenile documents. Davis versus Alaska in 1974 at 415 U.S. 308 said that the constitutional right of confrontation outweighs the juvenile privacy laws. Also, Pennsylvania versus Ritchie in 1987 at 480 U.S. 29 says that you can obtain juvenile records. They used to use an SDT to obtain juvenile records. In the state of California, it has now been reduced to a form. It's called a Petition for Disclosure of Juvenile Court Records, Form JV570. The trick with that code section is to make sure that you have provided discovery or a copy of the motion to everyone, both the county counsel in the juvenile case and the district attorney in the criminal case. Further, if there's a district attorney representing the minor in the juvenile case, you serve that second district attorney. In order to win that type of a motion, you need to be very specific in what it is that you're looking for. There are also privileges which must bow to the constitutional right of confrontation. The main one I'm thinking of is the psychological privilege in People v. Reber. It's a 1986 case, 177 Calap 3rd, 523. The court ruled that the constitutional right of confrontation outweighed the medical privilege. Everything was fine until the Supreme Court of California stepped in a case called People v. Hammond in 1997. It can be found at 15 Cal 4th, 1117. What they held was that Reber did not apply pre-trial, but only at the time of trial. Therefore, the judges could not do the in-camera hearing required by Reber and hand the documents over ahead of time. This is totally unworkable. All of a sudden, you're getting the documents in the middle of the trial, and you have to get a continuance. What I have been able to do with district attorneys to get around People v. Hammond is that they also want the data early so that they would agree to a stipulation that the court would get the records early and do the in-camera review early. That is not a stipulation that the records will be admitted or turned over, just that the evaluation in chambers can be done ahead pre-trial. Another type of discovery that you need to get is school records. The privilege covering school records has also been found to be trumped by the constitutional right of confrontation. However, if you do not comply with Evidence Code Section 49075 and 49076, you will not get the records. These statutes require notice to the school and a hearing in front of a judge before the subpoena ducis tecum can be issued. You have to comply with these code sections. Let's talk a little bit more about what we call the method. It's all about paper. Remember, the scanner is your friend. We scan all documents into the computer. Literally on my laptop, I have every single case that I'm currently working on. At the same time that we do these documents, we create what we call a jobs list and a theory of the case. It's just a word processing document, and you have it open while you read the documents for the first time. As you get ideas for the motions, theories of the case, you put them on this list. You also open up a word processing document called a chronology. Every time that you run into a date of any event, you put it in the chronology. Many times cases are solved by figuring out the order in which events occurred. Next, you create a word processing document called a witness list. You might have 1,000 pages to read, and on page 300 there's a janitor and his address, and he is totally irrelevant, and you don't bother to write it down. Then 500 pages of reading later, you find out that he's a key witness, and you want his address. Do you really want to go back over 500 pages and try to find it? I don't think so. We write down every name and every address that we run across in the discovery in an alphabetical word processing list. On this first read of the police reports, the other thing we do is to create trial outlines. Most attorneys do these just before the trial. We do it from the very beginning. As you read the scanned documents, you're making an outline. Maybe it's police report number 1, and then an outline of all the key points. Then police report number 2, an outline of all the key points. It's more time consuming at first, but in the long run, it definitely helps you save time. The other thing we do is we use a little program called Camtasia. And at this time, I want to use Camtasia to show you how we use multitasking in our work.
How we keep track of thousands of documents in a case. And not only how we keep track of the documents, but how we use multitasking to prepare for the case. First thing that we do is that we scan in all of the documents into one Adobe PDF file. This is an actual case here, and you'll see that it has 1,799 pages long. This is the bulk, the backbone of our cases. In fact, we carry every single case that we have on our laptops because of this. We organize this through the use of different tools. You'll notice over here on the left we have all the different dissolution files, harassment files, juvenile files, witnesses. Under a witness, you have each place that they've ever made any statement, and you can click on it and you're immediately to that person's statement, for example, like that. Now, that gives you everything they've ever said at your fingertips. The other thing is that the PDF file has the ability to run a search where you can look for any words that are contained in 1,799 documents. It only takes a few seconds. It also has the ability to put notes if you have you're reading along and you see a legal issue or something that you want to be able to find later and want to comment about it. Maybe it's a Miranda issue. You can put a post-it note, an electronic post-it note. The difference, however, is that these are all organized and you can get a printout of all of them at the end. By going to the index of the notes, which is in the comments section, it's like these. You can click on it and you immediately go to the highlighted area. These are the post-it notes, all organized by order. You can also search through your post-it notes. What else can you do? Well, let's close the search feature and let's close looking at post-it notes. You can also highlight, and when you highlight, it again creates an annotation that goes into a list. You can get a printout of the list, or you can look at the list. One of the things when you have a book, I've seen people with a book and they've got like 100 post-its on it, and then they can't find anything. Well, here you would have a list of 100 post-its. You could scan down the list or search down it, get what you want, click on it, and you'll go immediately to that position in your 1,799 pages. Sometimes there are photographs, so you can't highlight a photograph, but you can put a box around it. And again, When you do something like that, you can attach a note to the box if you want. Maybe it's a Miranda issue. I'm just making this up as we go along. And you can mark it up that way. Again, these will appear on the comments section. There it is, the one I just did. So when you click on that, you immediately go to it. And you can sort by post-it notes, you can sort by dates, you can sort by whether it's boxes or underlines or highlights, all of those types of things. By doing this, you really keep control over a very large volume of material. Now, the next thing, by the way, we have high-speed scanners. High-speed scanners are really cheap now. You can get them for less than $1,000, and the secretary scans everything in. So we've talked about bookmarking, we've talked about highlighting, and we've talked about post-its and boxes. The next thing that we do, and this is where the multitasking comes in, is we have two programs going at the same time, or multiple programs. Here you can see that WordPerfect is going, and we have the Adobe Acrobat. By hitting the keys Alt-Tab, you can bring up the programs that are running, switch programs, and here is where we really keep track of information. We have 4 documents. This is an old case, so it only shows 3 of them, but we have a witness list. Now, think of it this way. You're going to read the police report, and it's 1,700 pages long. At page 800, you run across the phone number of a person who you think is not important. What do? We immediately go from the document over to the witness list. We insert the name and the address right as we find it. Why? Because when you read another 500 pages and you find out that that witness really is important, the one you didn't think, you don't want to have to go back through 500 pages trying to find that address. The other things that we use this for is to communicate with the secretary. When we make a decision to subpoena the person, we put an S. If they're friendly, we put SM for subpoena by mail, and then we put no for those that we don't want. Some of our cases have 60 to 70 people in them. You might have 6 or 7 cases going at the time. You can't keep track of who 500 people are, so we put in the relationship, and then we put in why they're important. This is a document that is also used when they have an S. The secretary makes sure that the district attorney is notified of this witness as part of discovery. If we have an investigation report, I would put in investigation report, give to DA. That way she knows exactly what is to go out. Now, while you're reading those 2,000 pages, you're also going to be running across dates. So we keep a running tab of all dates. Every time we find it, we indicate it here, and we also put where that can be found. Many of these cases are really solved by understanding the sequence of events that occurred. So we keep track of that sequence with the chronology list. When do we do it? During the first reading. We make the witness list and the chronology list during the first reading. Like I said, this is an older case. During the first reading, we also have the jobs list. So as you're going along, you read something and you decide you have a question for your client, you write it down. Then maybe there's something that you need to do, and you're on another page doing some reading, and an issue comes up that you want to write a motion for. So I put down what a motion may be needed. Also, while we're going through it, it may come out that we need an expert. So we jot down the expert. This is organized by who's doing the work. The attorney, the expert. We also have a section for the investigator. And so if you get an idea while you're reading this of something that you want to have investigated, you don't want to have to remember what that idea was when your investigator comes to meet with you. You write it down immediately. Recently, we have started a new policy of having a fourth document, which is just the investigator's list. That way we can email it to him and keep a tight rein over what it is that we want to have investigated. The last thing that we do is that we keep a outline of every single witness. We'll make this one the witness. What happens is, as you read, you will maybe have a summary of a taped interview by the police. You'll put that in. You'll index it. You'll go on down, and this is making funny, strange lines on it. You might have one of your investigators doing an interview with somebody that knows about that witness. You may have a preliminary hearing that the witness testified at. As the documents come in, we add to them exactly what is going on. We do not wait until a week before trial. This is a matter of keeping everything up to date all of the time. When the trial comes, you've got your investigations done, you've got your experts done, you've got your motions done, you've got your outlines for your witnesses, and you have complete, very fast access to all of your documents. This is how we handle large volumes of document cases. Thank you.
Remember, it's about paper. What we want to do is get everything in one place, and that is in the scanned PDF file. Investigations reports come in. Even if they were in word processing format, we scan them in. Pleadings that were previously in word processing format, we scan them in. Motions, even though they were in word processing, we scan them in. Exhibits, we scan them. Transcripts, we scan them. We get them all into Adobe Acrobat. The reason being, once that document is indexed, every single thing that has to do with any witness is at your fingertips in one document. Now, it's also about audio. I recommend that you get rid of your tape recorders and purchase digital recorders. Tape recorders are only good at the most for half an hour to an hour. Digital recorders, you can have recorders that can record 20 or 30 hours. You don't need to worry about it. The quality is unreal. Digital recorders are good. What happens, however, if you're given an audio cassette? Well, what we do is we capture it and put it onto the computer. The bottom line is digital is good because it's easy to work with. Analog is bad. Here's a picture of our analog recorder with a tape being held by Dr. Lorandos, and on the other side I am holding a digital recorder along with a memory stick. Here is a short clip on how to use a recorder memory stick. This program can be set to default into whatever language you desire.
We're using Sony recorders, which are digital recorders, for purposes of dictation, and our investigators use them because they can literally record a 20-hour interview on one. But after you record it, how do you make use of it? And what you do is you use the memory stick voice editor. Okay, this is what it looks like. What you have is it automatically detects what drive it's on. Notice the little emblem of the memory stick. You can do several things here, the main one of which is you're moving it to your secretary's area, whatever that may be. Let's just pretend this is it. And you can drag it over, drop it, and it is now on your computer. Now, where did it come from? Where did the memory stick go? On computers, on laptops, the Sonys all have memory stick slots. And now a very nice little gadget is a 3.5-inch floppy that has built in with it 4 or 5 different memory card slots for different types of camera, different types of dictation equipment. You can take these items, which, like I say, can be up to 20 hours long. You can play them. You can play them right from here. However, in order to really do dictation, you would use wave pedal, which we will show you in another lesson. The next thing that we do is that we can attach these voicemails to emails. This allows the investigators to send you their either their dictation or their interviews, where you can have them transcribed over the internet. We use either email attachments, FTP, PC Anywhere, or transfer it using Go to My PC. This helps us be totally digital and mobile. Thank you.
The method is about video. Get yourself a digital camcorder. Don't get a Super 8. Don't get a VHS. Get a digital camcorder. The reason being, you can go from the camcorder directly into your computer. Once it's in your computer, you have total control over it. You can edit it. You can take out clips. You can insert the clips into closing argument. You can confront witnesses with clip after clip after clip of leading questions that they did during an interview, things of that nature. However, what if you were given an old VHS camcorder tape by the police? If you do, you then need to convert it, capture it, and put it on a computer. Turn it from analog into digital. Remember, digital is good, analog is bad. Here's a picture of Dr. Lorandos holding your classic VHS tape. And on the right-hand side is a mini camcorder, which I'm holding. Now, how do you convert it? You've heard me talking about that. Well, I spent a lot of time researching into this, and I found the best piece of equipment to do it. If you're given an analog tape, audio, or a videotape that's analog, you need what's called a Dazzle Hollywood DV bridge. You can buy them at CompUSA. There's a website from CompUSA. If you don't live near one, you can get on the web and order it. It costs about $250. Do not use video capture cards that fit into the computer. They look like old 1950 Chinese movies because the voice does not match up to the lip movement. You have no such problem with the Dazzle Hollywood DV bridge. And this is a picture of Dr. Lorandos pointing at the Dazzle Hollywood bridge. You can come in with an analog signal and convert it to a digital, and you can go in the other direction. You can take a digital signal and have it outputted as an analog. In this manner, you can edit and then put the finished product back on an analog tape if you need to. The method is also about audio. You've got to be able to hear the tapes. I've had numerous tapes where the audio quality is so bad. The last one I did, I sent out and spent over $2,000 getting a series of tapes cleaned of hissing and static and popping so that we could hear what was on the tape. Shortly thereafter, I discovered Magix, M-A-G-I-X. It's called Magix Cleaner. It costs about $39.99. You can order the program at their website, www.magix.com. The program is designed for amateurs. It will, by pressing a few buttons on a wizard, clean the audio sound of hissing, popping, and that type of thing. It was designed for vinyl records to be converted into clear digital sound. It works. It can also be used to capture analog. Here's a picture of the screen of the cleaner program put out by Magic. The silver buttons on the right you push, and it does a series of tests, samples the sound, and makes the adjustments. And then you can export it and save it. It's a very, very simple, intuitive program. Remember, the method is about video. It is also about audio. If you have a video, how do you clean it if it has bad sound? Well, you can export the audio sound and then put it through the Magix Cleaner program and put it right back on the video track. It sounds complicated, but it's actually very simple. Okay, you now have everything converted into digital, but you want to have transcripts. You have videos that you want to have transcribed. You have audio tapes that are on your computer that you want to have transcribed. Well, your secretary can't exactly stick the computer hard drive into her dictation machine. So what you have is what is called a wave pedal. It's sold by Sony, part number ICDWFT2. It's a dictation device. It costs $168.95. You can transcribe a video directly from your computer using this machine. It hooks directly into your computer's USB port and gives your secretary a foot pedal. Okay, we've now managed to put everything into digital format. The police have sent us VHS tapes. We've put them into digital format. They've sent us 8mm tapes. We've put it into digital format. They've sent us cassette audio tapes. We've put it into digital format. They've sent us standard audio tapes. We've put it into digital format. Plus, we already had in digital format anything that we recorded either on an audio recorder or on a digital camcorder. Now we're about ready to go to trial, and we need transcripts of these statements or transcripts of dictation, which has been done. Well, over here sits our old transcriber. Has a foot pedal, which is absolutely necessary for transcription so that the staff can back up and listen over and over on words that they have a hard time to hear. They can control the speed, and they have their headset. The problem is this only works with one type of audio tape. This particular one works with mini cassettes. We have another one that works with standard. These are now ready to be thrown into the trash can. But how do we transcribe something that is on the computer? Well, it's sitting down here on the floor. Let me get it for you. It's called a wind pedal. You can locate it on the internet by using a search engine. Just type in wind pedal and do the search, and you'll find a company near you that sells it. The cable runs into the back of your computer and plugs into a USB port. All you get is a CD-ROM of software and the pedal. When you load the software, on your screen will become an image of a transcriber. And you can set this to play at any speed you want, rewind any length of time you want, fast forward at any time that you want. And so this is how you do your transcription. You go ahead and load the file that you want, and it plays. You hear it through your digital headset and control it with your digital foot pad. The other thing about this that is really wonderful is that it also plays videos. So if you have a video, you do not have to separately record the sound off the video and then make a transcript of the sound. You can actually play the video on the transcriber program, Wave, and listen to the sound and transcribe it at the same time. It is the thing that makes all of the other work come together. Here's a picture of a digital sound headset. You notice the plug-in is for a USB port. This is not an analog headset. It's digital. The method is also about editing. Anything that is done in digital has counter numbers automatically assigned to it. You can use these counters in many different ways. For example, when your secretary makes a transcript of the audio or video, she can put counter numbers, 2 or 3 of them on each page. This makes it very easy for you to immediately be able to go to that location. This could be used for editing or actually during the middle of a trial. There is a certain portion that you want to play to the jury, you can go directly to it. What you want to do is cut up the video into clips having to do with specific issues. For example, leading questions or things like that. You do these ahead of time before you go to trial. You can then use these clips as building blocks for your closing argument. You can also use them during your cross-examination. How would you go about teaching your staff to edit this material? The best thing to do is to use Camtasia and give them an example of how they should edit. These are going to eventually be the building blocks of your closing argument, and therefore are very important. However, you want to spare attorney time that it takes to make these slides or clips. Therefore, you should use your staff for creating these. The method is also about pictures. You may want to use still pictures in your trial. The best way to handle them, however, is to scan them. Remember, the scanner is your friend. Now here's a photograph of a high-speed scanner, black and white, which is used for documents that's put out by Panasonic. This is a standard flatbed color photo scanner with a USB port. In fact, they have them so small that you can take them in your briefcase if you travel, or if you want to have a scanner with you during a trial. This is an HP photo scanner. It will scan photographs, it will scan negatives, it will scan slides and put them into digital format. It will cover everything that you need. Remember, once you have scanned these into your computer, they can be used during trial, and importantly, they can be used during closing argument. Remember, digital photographs can be used throughout the trial, both in cross-examination, presentation of your witnesses, and in your closing argument. You don't ever want to be caught in the position where you have a little 3x5 photograph you want to show to the jury, and the judge says no. It's much better to have a 3-foot by 5-foot photograph, then you don't have to worry about whether the judge is going to allow you to show it to the jury. Now, this is another type of scanner. It's a copier scanner, and it's networked, and it can be used throughout the office by anyone. And here's one of our pride and joys. This is a 24-inch wide photo quality printer. All of these documents that we scan can then be printed out on high-gloss paper, which you can see being held by Dr. Lorandos. We can then put the photos on boards if you want to have displays for the jury. If you don't have the funding to have such a printer, Kinko's has one of these printers. This is a little smaller version. This is an HP photo printer. It will accept all types of memory chips. You can see that in the top right-hand corner with the little display, and you can print out your digital photos that were taken with your digital camera, but only if you want small ones. It cannot handle anything wider than 8.5 inches. What we usually do is we have a small photograph and then a large blow-up of the same photograph. We mark the large one and use it during the trial, and then at the close of trial we substitute the small one. You need to train your staff in how to use the technology. When you're going to use technology to enhance your presentations at trial and preparation of trials, you need to teach your staff the technology. Don't teach them verbally. You can sit there and teach them how to load the ink cartridge on a large printer, and then a week later or a month later they will be asking you again how to do it. You can teach them how to map an external hard drive for capturing video on a weekday, and a week later they're asking you how to do it again. So what we have done is we have created a video library of every single thing that we do technology-wise, whether it's how to edit a video, how to clean an audio track, or whatever it is. And it's made up of 2 types of film, one of which we call, tongue-in-cheek, Men in Black. What we do is we dress up and put on dark glasses and have a little fun doing it, and we go out through all the steps of using the technology and the skills that are necessary for it. Secondly, people need to know how it looks on their computer, and there is a program called Camtasia. What we do is we turn on the Camtasia, and it records exactly the keystrokes. That's on the screen and shows how to do it. For example, you can demonstrate how to edit a tape, how to cut the first part of it off, the last part, and save a little portion of it. These are then kept in a library, and the names are made self-evident. And when somebody needs to know how to perform a technology function, they do not have to come running to us. They just double-click on the little video and get a 30-second, 1-minute, or 2-minute lesson in how to do it. Here is how you get Camtasia. It is ordered from techsmith.com. It's relatively inexpensive, a couple of $100, and it's well worth it. It can also be used for another purpose. We have to many times demonstrate something that happened on the internet in a courtroom. And I haven't found a courtroom connected to the internet yet. So what we do is we go on the internet and film it on Camtasia. And then we play the film for the jury so that they can learn about the internet. This comes up many times in child pornography cases and internet sting cases. And now Dr. Lorandos will talk to you about follow-up investigations.
Remember we talked earlier about the preemptive investigation that we try to conduct particularly during pre-files. If we're going to go to trial, the investigation continues. It's about motive. Motive, motive. Why would this happen? Why would the child have the kind of sexual knowledge that he or she does? What about all this prior bad acts evidence that's going to come in? What about the character evidence that we're going to want to deal with? We try to file as many motions as we can anticipate issues coming up in trial. We have collected numerous motions for all of us to use, and we've created a website to distribute these motions called CaliforniaMotions.com. We would like you to submit the motions that you use as well, that you think that would be of value to the rest of us. We'll put them up on the website for everyone to use. Here's a short tour of our motion website using Camtasia.
The next thing I would like to show you is another website that we have developed to help you. It is called CaliforniaMotions.com. CaliforniaMotions.com. It has many motions that can be used in defending somebody who's been falsely accused of sexual molestation. You can obtain your password right here, and this is where you log in. Let me put a password in. I wanted to remember the password in the future. And this is what it looks like. Now, here is a drop-down list to sort by types of motions. You can see different admissibility motions. They're categorized to help you find them easily. Let's take a look at motions regarding defense experts. You'll note that it immediately popped to the top of that. And here's some examples. Admissibility of an expert witness on coerced confessions in a PDF file, that's Adobe, Word document, or WordPerfect, child suggestibility experts, parental alienation experts, that type of thing. The only difference between yours and mine is you won't get a delete button. I think that pretty much shows you how to use it. Feel free to come and raid our motion banks. Thank you.
One of the most important things you're going to need to do in a trial that involves allegations of sex abuse is to use your job list to help you prepare your expert. Remember, the jobs list that Mr. Clancy talked about at the beginning of this hour is created as we go through the documents the first time. Don't forget, if you go to the expert asking for the answer, the expert is going to opine in a way that conflicts with your trial plan. You need to go to the expert with a sense of where your trial needs to go, and then ask the expert to supply you with ideas. Don't go to the expert asking for answers. Here's an example.
In Auburn, California, we had a case where a client was charged with torture of his child, and he ran the day before trial. 4 years later, when he was caught, he came to us. The prior defense attorney had no theory of why a 1-month-old baby's leg was broken with a spiral fracture. We went out and did our own medical research. The child had been born through a breech birth, so we obtained the medical records. The police had already interviewed the doctor, and the doctor said that he could not have caused the break. However, when we got the medical reports, we found out that it was a breech birth, and the doctor had reached up inside of the mother, grabbed the legs, and twisted the child into position to pull the child out and extract the child. We then used this information, went and research was done on whether or not that procedure had caused prior breaks in other children. And lo and behold, we found 7 or 8 studies that talked about that exact procedure causing breaks 1/3 of the way down the femur. It turned out that this break was 1/3 the way down the femur, and since it wasn't a complete break, so it went unnoticed for a period of time. It had healed, and in fact, when they found the break on the child, who was about 1 month old, the estimate was that the break was 3 to 4 weeks old. With this information, we then took these studies to a doctor who specialized in high-risk births and had him look at the research and the x-rays. In other words, what we are telling you is do your own research before you go to the experts. Many of these people will not take out the time to go out and do the research themselves. They'll give you an off-the-cuff answer about the issue.
You hear us say research, 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 science, science, science. Well, that's one of the mainstays of the Clancy Litigation Group in our trial preparation and orientation. It's really not as daunting as it may seem. First of all, how do you find an expert? Before I get into talking to you specifically about how you do your own research, let's talk a little bit about how to find an expert. Here are some commonly used expert witness banks. For medical forensics specialists and groups that consolidate experts who want to testify at trial and things of this nature, you can use any one of these that you see on your screen to help you find experts and choose from a variety of experts. But remember, you need to know where you're going before you consult an expert. Now, wading into the science on your own, well, you can use Medscape, you can use Psych Abstracts. You can do this. If you can do legal research, you can learn to do medical and psychological research. Use Medscape, Psych Abstracts, and databases of this kind. You can use part-time researchers such as a starving graduate student. Call your local graduate school, call up the medical school or the psychology department, and try to get a student who will help you do some research. Use the web. One of the things we've created for you is PsychLaw. That is the company that produces these videos for you. And if you go to the www.psychlaw.net site, you'll find a lot of useful free research tools for you. In preparing your expert, reading, highlighting, and outlining the psychological and psychiatric research is really important. After you've gone through the PsychLaw site or some other site and you've found a bunch of research that seems to be of value, how the heck do you understand this stuff? Many lawyers are afraid that they don't have any idea how to deal with this stuff. Well, here's a few clues.
Learning to read psychological literature. The value of reading peer-reviewed scientific literature, particularly psychological literature, is its use for impeachment in cross-examination. I'm going to teach you how to do this. First, we're going to use December 2001 article from Law and Human Behavior. I've made some bookmarks here so we can get through this quickly. In every peer-reviewed scientific journal article, you're going to find the same format. First, there's going to be the title and who did it. Here, in this case, this is Hunt and Borgida. And in this case, it's about interviewer modifications. That's when little kids get interviewed and the interviewer modifies what the kids has said, either has misheard it or purposely modifies it to their own agenda. Do kids conform their stories to modifications? Well, indeed, that's what this article is about. And all research articles start with what's called an abstract. That's a distillation of what the problem was, what they tried to investigate, who did it, and who they did it with, and what the results were. So we're mining these things for gold. Aha! Here's some gold, and I've got the highlighter tool activated. Preschoolers were most likely to incorporate modified misinformation into subsequent answers. Implications of these findings for investigative interviews are discussed. Well, excellent. Likely to incorporate misinformation. Well, we like that. After an abstract comes an introduction in a psychological journal article or any peer-reviewed scientific article which discusses where the science has been. The introduction talks about what the problems are that have been dealt with, how they're looking at the problems, the history of the research in the past, and in this case, we're again mining for diamonds and gold. Here we go. A recent study by Walker and Hunt, there we go, we'll highlight that, analyzed the types of questions used in a sample of Child Protective Services interviews of allegedly sexually abused children. Yeah, excellent. The The study documented a form of suggestive questioning called modification. So we're going to get this highlighted. Yeah, in these exchange. Okay, there's some gold for us. Demonstrates how interviewers can modify the memories of children and gives an example. Oh, okay, well, now we'll look for some more history. Oh, the tendency of children to agree or ignore modifications can have potentially serious implications for investigatory interviews. Yeah, that's a sentence that we like. Certainly we can turn that into a question in our cross-examination, or if necessary in our direct examination when we're trying to get the treatise described as generally accepted in the field, and use the description of the work in the field to lay a foundation to go after a particular forensic interviewer. Now, the next thing we want to look at after the abstract and introduction in scientific research is the method. What did they do? Well, first of all, who were the participants? In this case, the participants were 32 preschool children ages 3 to 5. Oh, okay. And college students? Okay. Interviews? Very good. That tells us who they worked with. And then what did they do? The next thing is the procedure. In any scientific journal article, the next thing in the method is the procedure. It tells you what they did. Well, okay, the experiment was conducted across. Okay, all right, there we go. That tells us, and the participants. So we're going to highlight this, and we're going to come back. Why are we using this? Because of its value in creating hypotheticals. Okay, and then after watching the video, oh, okay, yeah, and then all right, we've got acceptable level. Okay, open-ended questions. Yeah, we like that. We use this material, and if we know how to use our text grabbing tool, we can cut and paste this into an outline for ourselves for the development of our questions. Okay, we go on in our procedure section to find out that there were, oh, okay, 2 sets of follow-up questions. Okay, right, well, we'll highlight that. Okay, and it tells us a little bit more about that. Yeah, excellent. And then we want to know, well, how did the kids respond to these modifications? Well, as we move down, responses to modifications. Well, they coded the responses to the modifications as either agree with the modification, disagree with it, or ignore it. Okay, well, that tells us what the researchers did next. And as we scroll through the article, we want to know, well, okay, if that was the responses, what were the results? Well, in the peer-reviewed scientific journal article, the next thing you're going to come across after your methodology, and remember, psychologists who are scientists, not the junk science ones, are very concerned with methodology and the principles of validity and reliability in their methodology. So here we go, overview of their results. Well, we like that. As lawyers, we want to cut to the chase and get an overview, and this will give us more information than the abstract did, but still it's just an overview. So we would like to move on and see what kids did in response to their modifications. Uh-oh, statistics. Warning, warning. Well, but let's look at some of this and see. Maybe we can get a sentence that we can actually understand. Oh, okay. Only preschool children modified their responses. Okay, 22.5% of kids modified their responses. Okay, well, that's good. We could certainly use that in the development of our cross-examination, and that's why we're carefully going through our results section. Remember, psychologists that are scientists are keen on method and procedure, so we have to look closely at their procedure and their methodology. So let's see what okay, now let's move on and see what the next section is. Uh-oh, statistics. Warning, warning, statistics. Yes, Mabel, psychology is a science, and all of this gobbledygook certainly lends itself to demonstrating that. Uh-oh, more of this stuff. What is all this stuff? Probabilities. Oh, my goodness, look out. And so we look for discussion. Good, discussion. Oh, and here's a sentence that us as lawyers love, explaining the results. We love that. Okay, I look for what I call the bingo statement in scientific literature, and we've got one right here. This is wonderful. This is a great bingo statement to use in our cross-examination. The finding that witnesses rarely contradict interviewers' modifications, even when those modifications contain misinformation, is consistent with results of transcript analysis of investigatory interviews of alleged child abuse victims. And they cite who did those. Ho ho! Yeah, their findings are consistent with transcript analysis. Okay, well, let's see what else we've got in here. We'll find a few more little gems as we move through this thing, and we look at the kinds of, ooh, what was that down there? Let's see. Legal And interviewing implications. Well, that sounds like the basis of a good cross-examination question. And aha, here's another little piece of gold. Research has demonstrated that commonly used interviewing techniques can have serious deleterious effects on children's testimony. Well, yeah, that's important. And so we go, as we move through this, we find certainly in the beginning of many paragraphs, aha, here's another little piece of investigatory gold. The high frequency of modifications and low rate of disagreement with them may have serious negative implications for investigative interviews. Ha! Good stuff. Okay, well, where do we find these and other articles that support this position? Well, references. Here we go. And this is where we can send our secretary or our research assistant to get the material that they cited earlier in their article. That's how we read it. That's how we use it. You can do this.
What about the medical research? How do you prepare with medical research? Sure, none of us are typically medical doctors, but you know, it's not hard to get what you need out of medical research. Here's an example with Camtasia on how to approach medical research in this difficult field.
All right, now we're going to talk about how to read medical research. For this example, we're going to use McCann, Wells, Simon, and Voris's 1990 research published in the journal Pediatrics, and we're going to learn about their studies comparing non-abused girls to find out what is normal genital anatomy. The first thing we find in any good research article, and essentially any peer-reviewed article, is an abstract, and this gives us a background information about who, what, why, how, when, etc. And we may glean a sentence or two, and we're using our highlighting tool, and oh, here we go. After screening and looking at them with a colposcope, okay, what they did, all right, it gives us a sense of the girls that they were looking at, 114 girls, okay, good. And this gives us a sense of who they were looking at. The next thing, of course, that we want to look at is the method. Any good psychological and any peer-reviewed psychological or scientific treatise is going to give us abstract, discussion of what has happened in the past, the introduction, and then a method. And I've used some bookmarks here to get us through some of this. Here's our method section. Next, we want to go to our procedure. Well, procedure is particularly important because this tells us how and why they did what they did. And so we want to highlight that, and then we want to look for little nuggets of gold. The procedure, of course, will set the foundational requirements for use of the treatise as impeachment. And so we want to highlight this. Okay, how did they get these kids? All right, this is how they got the little kids that they wanted to examine. Okay. And then what did they do? Well, we go through this and we discover, oh, the examinations were performed by 3 faculty physicians from the Department of Pediatric Child Sexual Abuse Evaluation Team. Okay. Okay, that tells us what they did, who did it. They seem to know what they were doing. And then they tell us that they used the supine method and labial traction and knee chest position. Since physicians are not as paranoid about being seen as scientists as psychologists are, physicians don't do a very good job of defining their terms. They certainly don't tell us about labial separation or labial traction. But if we have a medical dictionary at hand, we know that labial separation means just keeping it apart, and we know that labial traction means pulling for a beneficial effect. That's what traction means in medicine. So we should keep a medical dictionary at hand, and many of them are available online as we go through these articles. We can do it. It's just a matter of getting through it slowly, like beginning law students getting through all those crazy terms like collateral estoppel, etc. And then we find here's another good sentence about the manner in which the inter-rater reliability was stressed. Now that's particularly important because junk scientists don't know what inter-rater reliability means. And they're discussing it right here in their procedure section. And as we move through the article, we notice that there are attempts at, oh good, definition of terms. Well, we'll come back to that because they define arrhythmia, increased vascularity, friability, all of these kinds of difficult terms that we run across with expert witnesses that we hire, and they're defined right here. We might want to cut this out and use this in other places at other times. As we move through the article, the next section after procedure is going to be who their subjects were. We talked about that, and then we're going to want to find out what the results were. Sure enough, here we have a results section, and in the results section they begin to tell us about what they describe in their tables, what it was that they were finding when they looked at all of these little kids to see what was and wasn't normal. And as we move through the article, we see that much of the research is developed into tables. Oh, here we go. This might be valuable. The frequency of external genital findings by position. Were they in the supine or knee chest position? What kind of things did they find? And then a heading like this is very valuable to us. The frequency of hymenal findings by method. Well, what method was used? Here they're using statistics again and demonstrating to us probabilities and for the kinds of things that they're finding. That's an excellent way of determining validity and reliability. And as we move through the article, we come to more tables which give us a great deal of good information in distilled form that we can use and we can certainly come back to. But let's take a look for the discussion. Here it is. What is it that they say that all of this means? We certainly want to highlight the discussion section and come back to it, and we may find things in the tables that are valuable to us in our particular case, because we may have a SCAN team or a sexual abuse team evaluator saying something about a particular child that we're dealing with, and it may be directly contrary to the normal findings of McCann and his team. And so as we move through the article, we find a variety of discussion about what it was that they find, and we occasionally find what I call the bingo statement. And here we go. Here's one right here, hidden among everything else. And we're going to highlight it right now. And it says, even in our present state of knowledge, it is becoming increasingly evident that as a consequence of naturally occurring physical changes, there will always be an overlap in findings between non-abused children and the victims of sexual abuse. Outstanding. That's very good for the cross-examiner. And here are references that we can send our secretary or our research assistant to go find for us if we need follow-up. That's how you get through a medical article. You can do it.
Medical research is not that difficult. In fact, Mr. Clancy won that Auburn case with the medical research that we developed in the Clancy Litigation Group. If we can do it, you can do it too. When you're preparing your expert, make sure that you pick an expert that you can work with, who knows the research and who can deal with the research. Remember what the Supreme Court said, that an expert's ipsy-dixit won't meet the admissibility test. That means that experts are not expert just because they say so. You're from Missouri. They got to show you. They got to know their stuff as far as you're concerned. Now, how do you prepare for your direct examination? Do you use lists? Do you use outlines? Do you use questions? When you're dealing with your expert, remember it's the research that's key. Any expert can come in and say, based on my personal experience, but that's all subjective. As we move from the old rules in Fry to the new rules of reliability and validity, subjective impressions about what testimony should be and subjective ideas about personal experience are going to fall by the wayside. When you're preparing your cross-examination for their expert, remember, use your research. Use your research. Use your research. Use the prosecution's expert's prior testimony, but don't slime. One of the things we see happening all too often is that the prosecutors will make only a personal attack on the proposed expert. Although the rules of evidence and the cases in California make it clear that the prosecution should not do that, too many trial judges let them get away with it. We say, that's stupid, don't do it. Don't slime. Use the research. Use their prior testimony. Take the high road. Now, when you're preparing your cross-examination of experts, there's another site that we've created for you. It's prosecutionexperttranscripts.com. We've created this site for you, and we'd like you to give us transcripts that you've gotten of prosecution experts. Here's an example of how to use the Prosecution Experts transcript site.
The next thing I would like to show you is a website we've developed called prosecutionwitnesstranscripts.com. prosecutionwitnesstranscripts.com. And let me log in. You can see over here you can obtain your own password to log in, and this is so that defense attorneys can share transcripts of expert witnesses. Now, if you have a transcript you want to share and you have it in some digital format, it could be Word, WordPerfect, PDF, or anything else, you click this button to upload your transcript. A menu will open and allow you to click on your file and upload it onto our website. It first goes to us for approval and for virus checking. Let's take a look at a few of them that we have. This is a drop down of some of the names that we have in so far. And let's take a look at this. Here's one that I know. Anthony Urqueza from the UC Davis testifies on child sexual abuse accommodation syndrome. Let's say you want to get prepared for cross-examination for him. Here is a transcript that was done on a case, and all you need to do, if you want to save the transcript on your own computer, is hit save, give it a name, place it anywhere you want on your computer, and that's it. Now this project will be useful with the more people who are willing to send in transcripts. If you don't have a scanner and you don't have the transcript in some digital format, you can mail us the paper transcript and we'll be happy to put it up on the website, and you can retrieve it, or your friends can retrieve it as you like. Thanks.
You've been preparing all along as each piece of information comes in. It's digitized and put into the system that we have developed. You are continuously updating the jobs list, you're continuously updating the witness list, you're continuously updating your chronologies and your outlines. Therefore, when it comes time for trial, you're pretty much prepared. The idea is you're really putting on a show. It reminds me of the movie Chicago. Remember? It's about a show, folks. It really is about a show. And here's where all that work pays off. You now have audio clips that have already been created as you review the tapes. You have video clips. You have digital photographs. You have charts. You have graphs. You have blow-ups. All of those things have been prepared as you are preparing the case, but not at the last minute. It's really about presenting a show. And once you have all of these key components, you can use them both during the presentation of the case and during the closing argument.
We hope that this has been helpful to you. We started in technology a number of years ago, and certainly we don't expect anyone to start off and be at this level. But this will give you a good start.
Don't be afraid of technology. It definitely increases your power in the courtroom. It helps you organize in your preparation, and your presentation becomes much more powerful. You need to develop a system of gathering, organizing, and presenting your case, and that's about presenting data in the most powerful method available. We hope that you like the idea of using technology. It will definitely increase the quality of your cases.
Hello, Cyclop presents the Clancy Litigation Group in another of our seminars defending against false allegations of sexual abuse. Today we're going to talk about trial preparation and the use of technology. We want to talk to you today about how we prepare child molestation cases for trial. There's a method of combining technology in case preparation. The use of technology is inseparable from case preparation. We'll also tell you about how to prepare your expert using the same kind of technology that we're going to talk about with respect to the facts and witnesses in your case.
We're going to start, first of all, by discussing what we call pre-files. In private practice, unlike public defenders, you often have a time when the client comes and hires you before any criminal charges have been filed against him. We call this a pre-file. It's the best time to meet your client.
The first thing we advocate is to tell the client that he or she is his own worst enemy. Tell them to shut up. Remind them about pretext phone calls, which is a technique being used rather extensively in California, where the child, with a cop listening on the extension, calls up and says,
Face a conflict or a fight between obtaining of juvenile matters and constitutional due process. However, you are allowed to get juvenile documents. Davis versus Alaska in 1974 at 415 U.S. 308 said that the constitutional right of confrontation outweighs the juvenile privacy laws. Also, Pennsylvania versus Ritchie in 1987 at 480 U.S. 29 says that you can obtain juvenile records. They used to use an SDT to obtain juvenile records. In the state of California, it has now been reduced to a form. It's called a Petition for Disclosure of Juvenile Court Records, Form JV570. The trick with that code section is to make sure that you have provided discovery or a copy of the motion to everyone, both the county counsel in the juvenile case and the district attorney in the criminal case. Further, if there's a district attorney representing the minor in the juvenile case, you serve that second district attorney. In order to win that type of a motion, you need to be very specific in what it is that you're looking for. There are also privileges which must bow to the constitutional right of confrontation. The main one I'm thinking of is the psychological privilege, or even through multiple questioning by investigators. You know, the first investigator asked him if the penis was hard, and the child looked in a puzzled way. The second investigator the next day asks if it was hard, and the kid answers the question. Why? Because he learned about sexual knowledge from the earlier interview. The other thing you need to do in an early investigation is to look for 1108 evidence, evidence of other wrongful acts by your client, and get to the witnesses as fast as you can.
it's important that you remember that your role is as the lawyer, not the therapist. The family members and the client, particularly during the preemptive investigation, are going to want to counsel with you. Remind them consistently that you are the lawyer, not the therapist.
What you want to do is to be a filter for your client. Gather all the information. Many times there may be some exculpatory information that could end the case before it even gets started. You don't want to subject your client to a police interrogation. However, you can be a filter and pass this favorable exculpatory evidence on to the police. Next, you should call the DA and let them know you're available in case they are going to charge your client. That you will surrender him so that you can make bail arrangements, and more importantly, so that any exculpatory evidence that you have can get in at an early stage and maybe nick the case in the bud. The next thing we want to talk about is the method by which we go about assembling data. The first thing you need to do is get that discovery. Remember, information is power. Get everything you can. Use our motion banks. We'll talk about that more later in order to get discovery. Obtain all the information that you can from your client and start assembling it. I recommend that you do formal discovery. There are too many times when I've been in the middle of a trial and the district attorney has popped up with something that they had not given me earlier. If you do not have a formal discovery order, it's going to be impossible to get sanctions. You should be using a subpoenas duces tecum or the discovery statute, Penal Code Section 1054, to get all of your discovery. The DA will sometimes play a game. Sometimes they will say, well, we're not required to get that discovery. We don't have it in our possession. And yet, if you issue a subpoena, they say you're not allowed to issue subpoenas because that's not part of the formal discovery rule. I have a way of doing it. I issue the subpoena to bring the documents to the discovery motion. Then, whichever way they argue, you have the other way covered. That puts an end to the game. In juvenile matters,
Why did you do this? Remind the clients to shut up. They are their own worst enemy. The next thing we advocate is a preemptive investigation. We always begin our investigation as quickly as possible after being retained. Why? Because we want to prepare the battlefield. Criminal defense attorneys are constantly responding as the tail, with the state and prosecution being the dog. Try to turn it around the other way. Prepare the battlefield. Stop the flash fires. Get everybody together. Circle the wagons, as it were, and try to get people to pay attention to the overall case plan. It's important to start this early because one of the things we are trying to do is win the hearts and minds of the various witnesses. We want to appear professional. We want to appear truthful. We want to get our investigation going in the right direction immediately.
what do you look for in the investigation? Motive, motive, motive. Anytime that you want to win one of these cases, the jury is going to sit there and say, why would they be making a statement if it isn't true? And so if your investigation has to focus on one issue, it needs to be motive. A secondary part of the investigation, especially with younger children, is sexual knowledge. A young child cannot describe intimate sexual acts. However, normally you will find out that they have learned it from their older brother, the kids at school.